Hi, it's Mike DelSignore, Massachusetts OUI lawyer. Today's video, I want to talk about what happens if you're arrested and your OUI is going to be heard in Attleboro District Court. Now, I have an office right next to Attleboro Court. I've been going to Attleboro District Court for my entire career, so I'm very familiar with the process. So your first date in Attleboro District Court is going to be the arraignment. You're going to check in with probation. It's right after you go through security. And then your arraignment is going to be in the first session courtroom. What an arraignment is, it's you being formally advised of the charges against you. The case will then be set down for a pre-trial. At the arraignment, you get a copy of the police report, but not all of the evidence. If there's body camera or video evidence, that'll take another 90 to 120 days for them to provide. You'll get that at the pre-trial date. So that's the process. First court date, the arraignment, you get a pre-trial date. So you're not on for trial. Sometimes people think the first court date's the trial. The office is not going to be there. You're just going to be notified of the charges and given a further court date to come back. This is if it's your first OUI. If it's your second offense, same process. Third or fourth offense, the arraignment may be more involved. There may be questions of bail, conditions of release. But first OUI, the arraignment is a very quick process. Next, what happens to your license? If you refuse a breath test, you're looking at a 6-month suspension. Basically, you're not going to be able to drive until the case is resolved, or unless you could get a letter from your employer. But you have to admit to the OUI. So while the case is pending, there's no way to get back on the road. But if you're found not guilty prior to the 6 months, there's a presumption of reinstatement. If it's a case that you don't want to fight or it's not winnable, you could potentially resolve the case. And if you could get a letter from work, get a hardship. If you can't get a letter from work, there's a way around that, but it's going to take longer to get you a hardship license. But generally, if you refuse, you probably have a good case. So don't admit to the charge without making sure you understand your options. That's where I come in. My goal, my approach is to try to help people win OUI cases, avoid a conviction. So call me, I'll go over the report and explain why your case is worth fighting. In most cases, they are. Field sobriety tests, they're very unreliable, they're subjective. There's a lot of reasons why maybe you didn't do perfectly on those tests. I can minimize claims of erratic driving and help get you a not guilty verdict. Now, the other side of the coin, if you took a breath test and it was over 0.08, the benefit is you only lost your license for 30 days. So while I'm fighting the case, you can get your full license back. And breath test evidence doesn't always come into evidence. So there's ways that I can keep that evidence from being considered by the court. So just because you took a breath test doesn't mean you can't win the case. That's the number one mistake a lot of attorneys make. They plea out cases too quickly because they say there's a breath test evidence, but there's reasons why these things are not accurate, they're not reliable, and that can help you get a not guilty verdict. If I can get the breath test knocked out, we can challenge it. Challenge the accuracy. The breath test is making assumptions about you that may not apply. Officers don't always follow the proper procedure in administering these tests. So I've won many cases with breath test results in Attleboro District Court and other courts all over Massachusetts. So that's a brief overview of what's going to happen to your license, the court process. Now, after your arraignment, your pre-trial, if the case is going to go to trial, the final court date will be your trial date. So my approach to handling OUI cases is to try to help people make the best decision possible for themselves. I'll consider your living situations, your employment, your goals, what you want to accomplish. And for many people, the best decision is to try to fight the case. If you don't fight the OUI case and you admit to it, you'll get what's called a continuance without a finding. That's technically not a conviction, but you'll be on probation for a year, have to do an alcohol education program. If you go to trial and lose, typically the resolutions, the disposition or the sentence is not going to be too much different from the quaff, except that you'll get a guilty instead of a continuance without a finding. For many people, that difference isn't really that significant. Guilty findings can be sealed after 3 years, so this isn't a permanent thing that's going to affect your record forever. Whether it's a quaff or guilty, it always counts as a prior OUI conviction. So my approach, try to help you make the best decision possible by giving you the benefit of over 20 years experience handling OUIs all over Massachusetts and handling so many cases in Attleboro District Court in particular. You can reach me anytime. Call, text 781-686-5924. I'll discuss your case, go over your options, review your police report, and help you come to a great decision in this case. Because whether you made a mistake or whether you arrested by an overaggressive officer, I'm here to help you. Mike DelSignore, you can reach me anytime, and I'll go over all your options on your Attleboro OUI case or an OUI charge anywhere in Massachusetts.